It is a great pleasure to address this conference today. We are entering a new geological epoch, the Anthropocene, in which for the first time our actions today fundamentally affect the future of our planet and the human environment. At the same time, we are in a kaleidoscopic world in which the emerging order is complex, often chaotic, with bottom-up empowerment and top-down control, rapid change, new challenges emerging quickly, and coalitions instantly forming across national borders. Patterns change, like a kaleidoscope, with different groups having handles to change the patterns. The principle of intergenerational equity addresses the kaleidoscopic world of the Anthropocene epoch. The theoretical basis is that all generations share in a planetary trust and are partners in caring for and using the Earth. We must pass the Earth and our natural and cultural resources to future generations in at least as good condition as we receive them, so that future generations can meet their own needs. The principle provides the foundation for sustainable development, but it extends beyond it and is relevant to other problems. Intergenerational equity has deep roots in diverse cultural and religious traditions, including the Judeo-Christian, Islamic, and Asian non-theistic traditions. In international law, the principle builds upon the use of equity. In the latter half of the 20th century, equity was invoked as a basis for allocating and sharing resources and for distributing the burdens of caring for the environment and its resources. The principle of intergenerational equity has deep legal roots, including in civil law, common law, Islamic law, customary law in African and other communities, and indigenous peoples' law. The United Nations Charter invokes the welfare of future generations. As the preamble provides, "We, the peoples of the United Nations, determined to save succeeding generations from the scourge of war." The 2015 Paris Agreement provides in its preamble, quote, "Parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on intergenerational equity," unquote. The principle is reflected in numerous treaties and other international agreements, in non-binding legal instruments, in many national constitutions, increasingly in judicial judgments at the national or subnational levels, and decisions of environmental courts in countries with such institutions. The report of the United Nations Secretary General in 2013 on intergenerational solidarity and the needs of future generations confirmed the existence of a fundamental principle of intergenerational equity, unquote. We can identify three components of the principle: comparable options, comparable quality, and comparable non-discriminatory access among generations. These encourage equality among generations, avoid predicting the values of future generations, are reasonably clear in application to foreseeable situations, and are generally shared by diverse cultural traditions and acceptable to different economic and political systems. Comparable options calls for conserving the diversity of natural and cultural resources. It means, for example, conserving biological diversity and respecting groundwater recharge rates. Comparable quality calls for ensuring that the quality of the environment is on balance at least as good as received. Inappropriate disposal of nuclear wastes, ocean acidification, desecration of soils, all cause long-term, severe, and potentially irreversible effects. Comparable access applies to climate change. If it becomes more costly to future generations to enjoy a stable climate, or the impacts from climate change make access to resources more difficult or costly. Using an intergenerational lens, we can identify important strategies for intergenerational equity. The most fundamental is to give future generations a voice in the decisions that we take today. This is challenging because we have to identify their interests and to ensure that those claiming to represent their interests are not instead pursuing their own at the expense of the well-being of future generations. The intergenerational lens also highlights the need for scientific research and technological development to understand the global and local environmental systems better, to identify and assess the impacts of our actions, to develop more efficient ways to extract and use resources, and to develop alternatives for meeting our needs that are less harmful to both present and future generations. Courts have been at the forefront of recognizing and applying a principle of intergenerational equity. While judgments of international tribunals have yet to rely on the principle, individual judges have noted its emergence and importance. In the International Court of Justice, the late Judge Monterey referred in the 1995 nuclear tests case to the principle of intergenerational equity as, quote, an important and rapidly developing principle of contemporary environmental law, unquote. More than a decade later, in the pulp mills on the River Uruguay case, Judge Gonzalo Trindade discussed intergenerational equity in extenso and noted that, quote, it can hardly be doubted that the acknowledgement of intergenerational equity forms part of conventional wisdom in international environmental law, unquote. A position he reaffirmed in the subsequent whaling in the Antarctic case in 2014. The most significant developments for the principle of intergenerational equity have occurred in national and subnational courts. Courts in more than 20 countries have referred to intergenerational equity or explicitly to a principle of intergenerational equity in their decisions. Courts have invoked the principle in two ways: in procedural matters, as by granting standing to representatives of future generations, such as children, and in substantive matters, as by finding that certain actions threaten the well-being of future generations or deprive them of benefits. The judicial decisions fall within four main categories: threats to natural resources of fauna and flora, pollution, administrative challenges to construction, and challenges to permits for mining operations. The recent cases concerned with climate change, whether in the United States, the Netherlands, Germany, Norway, Uganda, or other countries, implicitly reflect concerns with the well-being of future generations and intergenerational equity. These cases are likely to increase as we confront the potentially harrowing scenarios of climate change. Judicial development in three countries, India, Colombia, and Brazil, are especially noteworthy. At least four decisions of the Supreme Court of India incorporate the principle of intergenerational equity. On August 2, 2017, the Supreme Court of India issued an historic judgment in a large-scale mining case in which the court specifically discussed the principle of intergenerational equity and required the government to develop an updated mineral policy which would include intergenerational equity. In February 2019, the government of India issued a new national mineral policy, which contains for the first time a section entitled Intergenerational Equity and establishes an interministerial body to institutionalize a mechanism to ensure sustainable mining, quote, keeping in mind the principles of sustainable development and intergenerational equity, unquote. In another mining case involving the state of Goa, the Indian Supreme Court, citing intergenerational equity, called for a committee to determine an appropriate limit to the amount of minerals that could be extracted, and required as a condition for a permit to mine that a trust fund be established for the benefit of future generations. In Latin America in 2018, the Supreme Court of Justice of Colombia ordered the government to create an intergenerational pact for the life of the Colombian Amazon, to eliminate deforestation, and to take other measures to protect the area into the future. In Brazil, the High Court has handed down at least 5 decisions between 2007 and 2011 that emphasize the constitutional duty to protect the environment for future generations. Other judicial decisions incorporating intergenerational equity can be found, for example, in South Africa, the High Court of Kenya, and in courts in Australia and New Zealand. The proposed Global Pact for the Environment includes the principle of intergenerational equity, which is formulated as follows. Present generations shall ensure that their decisions and actions do not compromise the ability of future generations to meet their own needs. The language reflects the 1992 Rio Conference on Environment and Development and the 1972 Stockholm Declaration on the Human Environment. The 1997 UNESCO Declaration on the Responsibilities of the Present Generations toward Future Generations speaks of ensuring that the needs and interests of present and future generations are fully safeguarded. The 2013 UN Secretary General's report noted that, quote, the fundamental principle of intergenerational equity has, unquote, has been formulated as each generation should bequeath to its successors a planet in at least as good condition as that generation received it. The principle of intergenerational equity raises important questions. First, how do we give representation to future generations? Who speaks for them? Various proposals have been advanced, ranging from global guardians for future generations under the United Nations, ombudspersons for future generations, commission for future generations, and guardians ad litem in judicial proceedings, and also youth as representatives of future generations. Other proposals focus on the private sector, such as company shareholders concerned about future generations, or non-governmental organizations designated to represent interests of future generations. The second question, do we only have obligations to future generations, or do they also have rights? The principle of intergenerational equity imposes responsibilities on the present generation toward future generations. Whether it conveys rights as well as responsibilities may be controversial. One can argue that the obligations of the present generation to future generations constitute obligations for which there are no correlative rights, because the specific persons to whom the right attaches do not yet exist. But the rights of future generations are more nearly analogous to group rights that protect interests held in common, in this case by future generations. Intergenerational rights could be viewed as part of international human rights law, as specific aspects of their rights are implicit in the rights guaranteed in human rights instruments. And a third question, what is the relationship between intra-generational equity and intergenerational equity? We have serious equity problems today which must be addressed. Moreover, if people cannot meet their own basic human needs, they cannot be expected to meet intergenerational obligations. The principle of intergenerational equity recognizes that there may be trade-offs between meeting present needs and fulfilling obligations to the future. It provides a framework to consider competing demands so that while the interests of present generations are recognized, those of future generations are not ignored. In conclusion, the principle of intergenerational equity is essential for the Anthropocene epoch. The principle is critical to addressing climate change and the emerging challenges. Youth recognize this. They get it. In a kaleidoscopic world, with many different actors and rapid change, the principle of intergenerational equity gives future generations a voice at the table. It codifies the moral obligation that we all share to ensure that our actions today bring fairness to both present and future generations. Thank you very much.